The Advocates Act of 1961 stands as the bedrock of the Indian legal profession. It established the Bar Council of India, the governing body for lawyers, and laid down rules for legal practice. Now, in 2025, the government has proposed the Advocates Amendment Act. This act seeks to bring about significant changes to the 1961 Act. However, it has ignited a firestorm of controversy and dissent within the legal community. The proposed changes have raised serious concerns about their potential impact on the autonomy, integrity, and very fabric of the Indian legal profession. The amendment, according to the government, aims to improve accountability and transparency within the legal profession. It seeks to address issues like professional misconduct and delays in the justice system. However, critics argue that the amendments are a veiled attempt to control the legal profession and stifle dissent. The heart of the controversy lies in several key provisions that have sent shockwaves through the legal fraternity. The Advocates Amendment Act 2025 has become a battleground for a larger debate about the separation of powers and the independence of institutions in India. The legal profession, often viewed as the guardian of the Constitution and the rights of citizens, finds itself at a crossroads. The outcome of this battle will have far-reaching consequences for the future of law and justice in India. The stakes are high, and the legal community is prepared for a long and arduous fight to safeguard its autonomy and the integrity of the justice system. Section 2. Key controversial provisions, a threat to the legal profession. One of the most contentious provisions of the amendment is Section 35A. This section effectively muzzles lawyers by prohibiting them from engaging in boycotts or abstaining from court proceedings. Such actions, if undertaken, would be deemed professional misconduct, leaving lawyers vulnerable to disciplinary action. This provision strikes at the very heart of a lawyer's right to protest and raise their voice against injustices within the judiciary. Another controversial provision seeks to grant the government the power to nominate members to the Bar Council of India. This provision has raised serious concerns about potential government interference in the functioning of the BCI. The BCI, traditionally an autonomous body, plays a crucial role in regulating the legal profession and upholding ethical standards. Allowing government nominees could compromise the BCI's independence and impartiality. The amendment also proposes to open the doors to foreign law firms, allowing them to operate in India. While proponents argue that this will foster competition and improve legal services, opponents fear that it will marginalize Indian lawyers and disadvantage ordinary citizens seeking justice. The entry of foreign firms with their vast resources and global networks could create an uneven playing field, making it difficult for Indian lawyers to compete effectively. Furthermore, the amendment introduces stricter enrollment restrictions for aspiring lawyers. It empowers state bar councils to deny enrollment to individuals convicted of offences carrying a prison sentence of 3 years or more. While this provision aims to maintain the integrity of the profession, it has drawn criticism for potentially being used arbitrarily to target individuals based on political motivations or personal vendettas. Section 3. A nation in uproar. Lawyers' protests and strikes. The response from the legal community to the proposed amendments has been swift and resolute. Lawyers across the country have taken to the streets, organizing protests and demonstrations to express their outrage and opposition. The epicenter of these protests has been Uttar Pradesh, where lawyers have staged massive demonstrations and boycotted court proceedings. The Bar Council of Uttar Pradesh has called for a statewide strike, bringing the legal system to a standstill. The protests have not been limited to Uttar Pradesh. In Punjab and Haryana, lawyers have also joined the chorus of dissent. The Executive Committee of the Punjab and Haryana High Court Bar Association has announced a strike, with lawyers abstaining from work to demonstrate their solidarity with their counterparts across the country. The strike at the Punjab and Haryana High Court, a prominent legal institution, highlights the widespread discontent within the legal fraternity. These protests are not merely about protecting the interests of lawyers, they represent a fight for the soul of the Indian justice system. Lawyers argue that the proposed amendments, if enacted, would have a chilling effect on the legal profession. The fear of disciplinary action could deter lawyers from taking up sensitive cases or representing clients who are critical of the government. This would undermine the very foundation of the legal profession, which is to ensure access to justice for all, regardless of their political beliefs or social standing. The widespread protests and strikes by lawyers across India are a testament to the unity and strength of the legal community. They are a clear signal to the government that any attempt to erode the independence of the judiciary or stifle dissent will be met with fierce resistance. The legal profession is prepared to wage a long and arduous battle to protect its autonomy and ensure that the flame of justice continues to burn bright in India. Section 4. A looming shadow: implications for the future. The Bar Council of India, the apex body representing